Before you is the legal team of our client, Willis Raburu, who gave us firm instructions to move to court with utmost urgency in a bid for him to enforce his rights, which have been grossly violated by the EABL owing to a contract that they entered into where our client, through his company, enforced the contract, performed to its obligations, and delivered what was required. However, since 7th December 2024, our client has not been paid. There has been no communication, and it appears that the people we have sued are trying to evade liability on the basis that the contract was never signed on their part. However, what the law provides is there was the offer, there was the acceptance, and there was the performance. And consequently, consideration must then be met. Consideration in terms of money. To date, our client is being harassed by suppliers and by fellow artists who are of the opinion that he might have been paid and have refused to remit the finances. This has caused him not only financial loss, but also his reputation of his brand is at the mercy of EABL, owing to the fact that they have a stronger financial muscle over artists. We have seen this emerging issue in our country, whereas in this day and age, there are artists who can live and work for gain as artists, but sometimes they are forced to enter into contracts by big brands who have bigger financial muscle and refuse to honor their part and refuse to pay artists, which subjects the artist industry to a lot of anguish, a lot of desperation, and financial loss. As recent as last week, we saw through, there was a report that was established that in Kenya, in this year, most Kenyans are listening to Kenyan music. Therefore, we cannot say that the artists are the lowest in the food chain, but they are being taken advantage of by big corporations who are trying to evade liability on basis of small technicalities, and therefore we have moved to the High Court with utmost speed and urgency, asking that the High Court to enforce and protect the rights that have been grossly violated of our client. He remains to be a person of reputable brand, and this does not affect his brand in any way because he moved to court as a matter of right, as is provided for under the Constitution, where anyone can move to court to exercise and enforce a right that is likely to be violated or a right that has been violated. We are hoping that with utmost urgency, the court will certify our matter urgent and place it for directions before the incoming court vacation, and that our client and all his suppliers and all his contacts will be able to enjoy the fruits of their labor that they were waiting for since last year, December 7th, 2024. It's over a year. There has been no communication and no settlement thereof, and as such, we are asking these big corporations that are seeking for artists who help and sustain the ecosystem that is concerning their business to respect the right of artists, to pay the artists, and to hold them in the regard, because without them, they would not be as successful as they are. They are the direct consumers, and they bring the direct consumers straight where the corporations cannot reach, the artists reach. And therefore, this is a gross violation, and we are calling upon them to act right and respect each and everyone's rights. No one is above the law, irrespective of your financial muscle, irrespective of the brand that you have.